right, good morning. Do we have Mr. Romero there at the jail, the main jail?
Good morning, Judge. Yes, we
Mr.
do.
Romero, nice to see you.
Nice to see you, Judge.
All right, is everyone ready to begin? We're going to go ahead and get started. Good morning, everyone. We're here for first appearance docket. I am Judge Giuseppina Miranda, and I will be presiding over the hearings this morning. If I could please ask the attorneys to state their names for the record, and then we'll get started, starting with the state.
Eric Linder on behalf of the state.
Thank you.
Brian Reedy from the Public Defender's Office.
Thank you. And then finally,
Hector Romero with the Public Defender's Office, Judge.
thank you. Good morning, everyone. We're going to go ahead and start with our first case. It seems to be, yes,
I'm being advised by the deputies if we can call a gentleman out attorney. He would be on page 27. His name is John Rufalo.
okay. I'll do my best to find Mr. Rufalo's paperwork. Happy to get.
It's probably towards the end of your pack.
It's
Mr. Rufalo, come on up, please.
How many pages are there on the docket? Oh, here, I found him. I found him. Thank you so much.
Thank you.
All right, Mr. Ruffalo, good morning. I have a matter here where you have been charged with a battery on a law enforcement officer and resisting officer without violence. If I can hear from the state regarding Mr. Ruffalo's background and what you're proposing for a bond, please.
Your Honor, as far as criminal history, as far as Broward, he has a trespass that he pled out late January of this year. Based on the totality of the circumstances and these allegations, Your Honor, I'd be requesting a $1,500 bond.
Okay. Mr. Romero, anything on behalf of your client?
One moment, Judge. Judge, I was just discussing with Mr. Ruffalo if there was anyone I can contact to help post that monetary bond, and he does not believe so. Judge, as you heard from the state, he has not significant contact with the criminal justice system. He's 34 years old, been living in our community now for well over 15 years. At this time, he advised me that he's currently unemployed, but he's actively looking for employment. Now, he lives in Boca Raton by himself. His rent, where he does not own, he rents, is approximately $750. Judge, considering this is his limited contact to strong ties, I'm asking for the court to consider releasing Mr. Ruffalo under supervision with pretrial release.
And Your Honor, just so the court's aware, he doesn't have limited contact. When you asked, I had only had access to his Broward priors. I'm getting hits out of California, Washington State, New York, Montana. As far as the state of Florida, he has 7 prior felony convictions.
And this man should have been taken to the hospital, Judge. This man should not have been taken to the jail. They were in the process of Baker acting him, and according to this report, when he spit on one of the officers, they decided to arrest him and take him to jail instead. And this is how we develop problems in the jail with people who are having type of mental health issues and are not properly treated by Broward Sheriff's Office. And that's the situation that we have here.
Well, I can appreciate that you may feel that way from reading the small amount of information that's contained within the probable cause affidavit, but the probable cause affidavit does list sufficient information to make me feel that there was a battery on a law enforcement officer. Given the circumstances, I believe that the state's recommendation of a $1,500 bond is more than reasonable. I'm going to go ahead and adopt that recommendation. Thank you, sir.
Judge, my last request.
$1,500. Yes, sir.
Would you sign a photo order so we can photograph Mr. Ruffalo's injuries? Judge?
Absolutely.
Thank you,
And as
Judge.
we can
Thank
see
you.
for the record, he does have an injury to the bridge of his nose.
Yes, sir. And that's obvious from his booking photo as well. All right, thank you, everyone. Moving on to the top of the docket, then, we have Miss Barbary.
North Broward.
North
Can we
Broward,
put her
thank-
on recall?
Yes, absolutely. Let me know when we can go back to her.
Thank you.
Next, we have Miss White. Where's Miss White?
She's here present at Maine, Judge. Come on up, Ms. White.
Good morning, Ms. White. I've had an opportunity to review your probable cause affidavit. I do find probable cause for the 2 counts of a battery and abuse of a child without great bodily harm. Recommendations from the state regarding a bond?
One moment, Your Honor. The state would be requesting a excuse me, a $5,000 bond per count in order of no victim contact with either alleged victim. This is based on the allegations in the report, her criminal history out of Broward, a 2010 theft, and theft and date in '09. Nothing further, Judge.
Thank you. Mr. Romero, anything on behalf of your client?
Yes, Judge. And speaking with Ms. White, as you can see from what the state advised, she has no prior violent offenses. She did advise me she is a registered voter in our community.
Can
Can
she afford anything?
She can, Judge. We're going to be asking for a $1,000 bond on count one and a $2,000 bond on count two. That's what the defense is requesting, Judge. And she currently works as a hairstylist, and her wages fluctuate with her customers. So that's why we're asking that monetary amount, Judge.
I was considering a little less, but I'm happy to go ahead and do 1,000 on each count. The more concern I have is that there be no victim contact. I don't know if Children's Services is involved in this case or not, or if the child has someplace else to go. Ma'am, until all of this is over with, I'm going to ask that you not have any contact with your child, either directly or indirectly. You're not permitted to ask any family members or friends to have any contact with her. And obviously, if DCF is involved, then we would defer to them as to what type of contact you have. If the family judge decides to permit you to have supervised contact, that's fine. But as it stands right now, a condition of your bond is no contact either directly or indirectly with your child. I need to make sure that you understand that condition.
You understand, ma'am? Answer out loud.
I need for you to answer out loud, ma'am, please. I know this is difficult.
Yes.
Okay. All right. Thank you, ma'am. So it's $1,000 on each. You can post that bond whenever you're ready, ma'am. Okay, next we have, let's see, next we have Yamalia Cordovi.
No problem, John.
Thank you. Switching to North Broward. All right, thank you. We have, it appears that there's a competency status hearing scheduled for next week before the assigned judge. There's a $5 bond on count one and no bond on count two. Anything from the Public Defender's Office?
Well, we don't have a problem with the bond amount on count one. The bond on count two should be an ROR, actually. At least she's required
It
to post
is.
the
It
bond
says
on that.
0 ROR.
Okay. That's
Okay? All right, so you have a hearing date next week with your judge. If you're able to post the bond, you have to make sure you come to that hearing date. Otherwise, your judge will see you next week. Good luck to you.
Okay, thank you.
You're welcome.
Excuse-
Yes.
John, excuse me, I
Yes, sir.
have Miss Barbary here.
Oh, terrific. Thank you. Going back to Miss Barbary.
Thank you.
All right, Miss Barbary, good morning. We're here on an aggravated assault with a deadly weapon, domestic violence charge. I have had the opportunity to review your probable cause affidavit. I do find probable cause. I'm gonna go ahead and, ask the state for their recommendation regarding a bond, please.
Your Honor, state will be recommending a $10,000 bond based on the level of violence alleged. Also, Ms. Barbary has 2013 child abuse. I'd also be requesting an order of no victim contact.
Mr. Romero? I'm sorry, this one's
Judge, they
yours.
just bought her down. I haven't had a chance to speak with her about her ties to the community.
Okay.
You give me a brief opportunity to do that.
I'm happy. So, ma'am, we're gonna, unfortunately, I have to put you on recall one more time. The lawyer wants to talk to you for a couple of seconds and get some information about you so I can make a decision as to what kind of bond to give you, okay? They're gonna show you where the telephone is so you can speak to the lawyer for a few minutes, all right?
A lawyer?
Yes, ma'am. We're appointing the Public Defender's Office. Go ahead. Okay, we'll put her on recall. Next we have, is it Miss Herring? Where's Miss Herring? At the main jail?
Correct, Judge. She's here. She declined the service of public defender. She has private counsel.
All right, ma'am, good morning. Before you say anything, I do need to advise you that you have a right to have an attorney represent you at this and all hearings, and if you cannot afford an attorney, we can look into the possibility of appointing a lawyer to represent you. The public defender seems to think that you have an attorney to represent you. I need to find out from you right now, would you like to go forward without your attorney, or do you want me to try and contact your lawyer?
I can try to go forward without him.
Okay, if at any time during this conversation you feel uncomfortable going forward on your own, please stop me. I'm happy to try and reach your attorney for you and see if we can reach them. In the meantime, please also understand that this hearing is being recorded and anything that you say regarding your case can be used against you. So I ask that you not tell me anything about the facts of your case. What we're really just trying to do here is decide what your bond should be today. Also need to inform you that apparently you do have a hearing scheduled next week at 9 o'clock before a judge. These are all traffic capiases. You have 5 different warrants for your arrest, and the bonds that have been posted on each of these vary. Count 1 is $100, count 2 is $1,000, count 3 is $500, count 4 is $500, and count 5 is $500 currently. At this time, I would be looking to see if I would be willing to reduce any of these, or in finding out from you whether you could post these. If you get a bondsman, you have to post a certain amount, or you can post the money on your own. I'm gonna hear from the state first to see if they have any information about your background before I consider changing any of these, okay?
Okay.
Mr. Linder?
Your Honor, I'm showing that her license has been suspended 18 times
18
for
times?
failing to appear in court.
Okay, so ma'am, the state attorney is telling me that you've had unfortunately a history of not showing up for court regarding your driver's license and its suspension. Don't tell me about the facts of the case. I just need to know, can you afford this bond, or do you want me to consider to reduce any of them?
I didn't really hear the amounts of the
The
bond.
amount total would be, let's see, it would be 1, 2, so it'd be $2,600 total.
You can try to reduce it.
Okay, the only way that I would reduce it is as I have to find out, about your background, about where you live, and about getting some assurances from you that you would actually come to court and not miss hearings. You do have a hearing scheduled next week.
I can post it then. I
Okay,
just
all
gotta
right.
post it.
All right, very good, ma'am. If you do post it, understand that you do have a hearing next week on the 29th at 9 o'clock.
Okay.
If you fail to appear, there'll be another capias issued for your arrest, and you'll lose all your bonds, okay?
Okay.
All right, ma'am, good luck to you.
Back to Ms. Barbary if you choose.
We can go back to Miss Barbary at the, was it North Broward? Thank you. All right, we're back on, and I did find probable cause, sorry, I forgot to check that one off. We're back to Miss Barbary. All right, Mr. Reedy,
Yes, Judge, I think the state had been asking for a bond of
10,000?
10,000.
Yes,
I think there are a lot of issues here, Judge, that we're gonna need to look into.
okay.
I don't think she's gonna be able to make a $10,000 bond or a $1,000 bond or a $100 bond, quite frankly. I would ask for a $2,500 bond on this case.
And what's her background?
Child abuse from 2013.
And her ties to the community council? Has she
Judge,
been?
she's lived here all of her life,
Okay.
and she's been staying in the same location for a lengthy period of time. She's a patient at Henderson Clinic right now. Unfortunately, she was not able to provide me with any phone numbers of anyone that I could reach out to assist her.
All right, Miss Barbary, whatever amount I decide on in just a moment, one of the conditions of my bond that I'm going to be requiring of you is you're not to have any contact either directly or indirectly with the named victim in this case until this matter is resolved. That means you can't have any family members or friends try to call him, write him, text him, email him, anything like that. Do you understand that? And you have a question? All right, just don't talk about the facts of the case, but tell me what the question is.
I want Helen Jean Barbary locked up.
Okay, so I understand that you may have a problem with him right now, but I can't do anything about that. Your lawyer will help you through that process. As it stands right now, I'm gonna go ahead and reduce the state's recommendation to a $5,000 bond and no victim contact. So please, ma'am, if you post your bond, you're not to have any contact with this person. Your lawyer will tell you how to proceed if you believe that there should be some charges filed against him, okay? Good luck to you, ma'am.
Thank you, Judge.
Next
Okay.
case
All right, good luck, ma'am.
is Ann Sheeny.
She's a medical research order.
Thank you.
Mr. Reedy, can you call me, please?
All right,
Thank you.
next we have Julia Fieldman. Where's Julia Fieldman?
Your Honor, Paul Ryan facility?
I'm sorry, did you say Paul Ryan?
Yes, ma'am.
Okay, thank you. Good morning.
Unfortunately, she's downtown in court today.
She's in court today?
Yes, ma'am.
Okay, so apparently, Julia Fieldman is at court right now, so I can't do her, first appearance. You'll reset her to tomorrow? Okay, either that or can the court judge that she has right now do her bond hearing?
I know that she's waiting for a program on counts 1 through 3.
Okay, well, if that.
So they
if
might
this-
be addressing that issue this morning.
They might be, so if necessary, you all will reset her. Okay. Next, we have, Brenda Ambrose.
Your Honor, I'm going to ask this to be placed on recall. Ms. Ambrose is going to need a sign language interpreter.
Oh, okay, very good. Well, we'll go ahead and make arrangements for that. I do see that there is a hearing coming up on May 10th regarding a competency placement. So we'll we'll recall that in just a few moments. Next, we have, is it Ebony West?
North Broward, Your Honor.
Thank you, North Broward, switching to North Broward. All right, we have, I've had an opportunity to review this. There's an attempted felony murder and a second count of robbery with a firearm. I've had an opportunity to review it. I do find probable cause. Mr. Linder, the state's recommendation?
Your Honor, the state is going to be seeking a finding of proof evident or presumption grade for first appearance purposes only, relying upon the arrest warrant affidavit and seeking a no bond hold on both counts.
Thank you. And Mr. Reedy, I know that you were just hanging up the phone. The state is
No,
requesting.
I heard what Mr.
Okay.
Linder had to say, Your Honor, and I reviewed the information regarding Ms. West's case. We would be objecting to the court setting a no bond hold or making a finding of proof evident presumption grade at this stage of the proceedings. The state has failed to produce any evidence or any testimony. They've introduced no physical evidence. They're relying solely on an affidavit written by an officer who did not witness the events himself. Based on that, I would ask that this court set a bond for Ms. West at this time. If the court, over our objection, makes a finding that proof evident presumption grade has been established, we would then ask the court to exercise its discretion and set bond for Ms. West.
All right, thank you very much for your arguments. I'm going to go ahead and find at this time that there is proof evident and presumption grade based on the affidavit to arrest, and I am going to decline to set a bond at this matter. However, I am going to go ahead and make it clear that the bond issue can be addressed by the assigned judge at any request for an Arthur hearing. Thank you. Good luck to you, sir, ma'am.
Yes, and I did explain that to Ms. West, and I will be calling your mother for you, Ms. West.
Next, we have, is it Ms. Patterson?
Medical research, Your Honor.
Medical reset, all right, thank you.
Yeah. Oh, no, you can't have it. I own it. No, it's mine now.
Medical reset on that one. Next, we have Lois Darby.
Paul Ryan, Your Honor.
Thank you.
Welcome.
Good morning, Ms. Darby. I have a probable cause affidavit here in front of me that has charged you with 2 counts of grand theft. Each of those counts carry with them usually a $1,000 bond. I do find probable cause at this time. Any changes that you wish for me to consider regarding the bond? But that's for your, that question is, that question's for your lawyer, ma'am. I apologize.
I'm sorry.
That's
That's
okay,
okay.
Judge. I'd kind of like to hear what she has to say anyway.
Okay,
Can you make
you-
that bond, Ms. Darby?
Can you make that bond, ma'am?
I didn't get a phone call yet, so I don't know.
Okay.
Is there someone I can call for you to post bond for you?
I don't know. I don't have my phone numbers or anything, so.
Where's your phone?
It's at my work where they picked me up at.
Okay. Mr. Linder, what's her background, please?
One moment, Your Honor. I'm
Thank you.
showing out of state of Illinois. Excuse me, felony possession controlled substance, 2015. In the early 90s, forgery and counterfeiting. There are other priors in Illinois, but obviously they're more dated, so I won't go into that any further. That's all I see, Judge.
Doesn't sound like the worst record in the world, Judge. Do you have a place to stay, Miss Darby?
Yes, I do.
Okay,
How
I
long
would
have
be
you s-
willing to reduce them both to $500 apiece.
All right, I'm gonna call you, Miss Darby, to see if I can find out who I can call. Would the court consider pretrial release for Miss Darby? I mean, if I'm not able to get a hold of anyone, she's not gonna be able to bond out, even though the court has generously agreed to reduce the bonds. If she's on pretrial release, she'll be supervised. They'll be keeping track of where she is. She'll have to call in. She'll have to report in person.
Am I reading this correctly? Are these old cases? Oh, no, they're
It's a
2018.
2018
Okay.
case. It's a grand theft
I see
at the
when,
Dollar Tree
I see,
store
I see.
from April 24th of last year.
of last year.
I don't know how you can actually steal 150.
No, it's $1,500.
$1,520
If
worth
you
of
read
stuff
it
out
all-
of a dollar store.
If you read it carefully, you'll see
the
that
money they
there's
made
a
that day.
situation where she's alleged to have been an employee.
Yes, I see that, Judge.
Okay.
And I
So,
think she would agree not to return to that location.
any objection from the state to consider pretrial release?
No, Judge.
Okay, can I put it on here that if she's qualifies for pretrial release, that she can be released without bond, or how do I have to write this? Pending verification. Okay. Pretrial release pending.
So Judge, while she's pending verification, are you reducing the bond to 500?
Yes, ma'am. I'm gonna keep him at 500, and if she doesn't qualify for pretrial release, then she'll have to post the bond. If she does qualify for pretrial release, she can be released without the bonds. Thank you. All right, good luck to you, ma'am.
Thank you.
All right, Norma Gribble? She posted bond, very good. I do find probable cause
That is
based on.
correct, Judge.
I found probable cause on that one, and then next we have Joanne, Balkulis?
North Broward.
She's in
North
North
Broward.
Broward, Judge.
North Broward. Good morning, ma'am. I have a charge here of possession of cocaine and tampering with or fabricating physical evidence. Both of them carry with them a $1,000 bond. I do find probable cause. Are you able to post those bonds, ma'am, or do you want me to consider reducing them?
I would ask the court for pretrial release for Miss Balkunas. I don't know if the state objects.
Does she have a background? Thank you. Ma'am, we're considering pretrial release for you at the request of your attorney. If you'll give us a moment, I just need to know what your background is, okay?
Yes, ma'am.
Looks like she has shoplifting priors out of New Jersey from 2010, 2011. Looks like she went to state prison in New Jersey on a violation of probation revocation, obtaining controlled substances uttering a forged instrument. That was involving, it looks like it was involving prescriptions.
And when was this?
That was in 2010.
Anything recent? Ma'am, how long have you lived in Broward County?
Most of my life,
Okay,
I was in Jersey.
okay.
The most recent thing I see, Your Honor, she was arrested February 23rd of this year for capiases on 3 separate municipal ordinance cases.
She has lived in the same location for the last 2 years, Judge. She has 3 children. She has a job with a moving company. And so we would be asking, but I don't believe she's going to be able to post a monetary bond.
Well, I mean,
What, Mr.
I'm
Linder?
just curious what location that is, because both the probable cause affidavit and the booking sheet appear to indicate that she's homeless.
Ma'am, do you have a place to live?
No,
Okay.
What about the friend that you said you were living with? Is that
I
someplace you
can't
can
stay with
go?
my friend.
Huh?
I can't stay with a friend.
You can stay with a friend, but it's
Yes.
not your permanent residence?
No.
Okay. I'm gonna go ahead and maintain the bonds as is. Good luck to you,
Is the
ma'am.
bond?
I'm gonna leave them at the $1,000 apiece, ma'am. All right, next we have Hope, Valdovina.
Valdivinas, she's approaching, Judge. Come on up,
Thank
ma'am.
you. Main jail.
Yes, Judge.
All right, ma'am, you have a grand theft case that's pending before you right now. Does she have any priors?
Checking that right now.
Can she post her bond, Mr. Mayor?
Bond is being posted.
Her bond is being posted right now.
Beautiful.
Ma'am, someone appears to be posting your bond. Were you aware of that? It's posted, so she'll be able to get out. Ma'am, I do find probable cause. Good luck to you.
Thank you.
All right, Jessica Cruz.
Ms. Cruz is approaching, Judge?
Appears to be the same incident.
Correct, Judge. Co-defendant.
Ms. Cruz have a,
Judge, my understanding, she has never been arrested in her life, if the state can confirm that. My understanding, this took place at Dillard's. Considering this is a nonviolent offense, I'm gonna be asking the court to consider releasing her on straight ROR.
I see no history, Judge.
there's no history? Okay.
She will be coming back to court. Judge, she has very strong ties. She's been here her whole entire life.
Ma'am, do you have a permanent address?
I do.
Okay. Do you live with family or on your own?
I live on my own.
Do you have a job?
I do. It's like seasonal. I bartend gigs here and there.
Okay. Any objection to a release?
No, Judge.
No? Okay. Ma'am, I'm gonna go ahead and release you on your own recognizance. What that means is that you're permitted to be released without a bond of any kind and without supervision. However, please understand that you have to make sure that you come to your next hearing date. If you fail to appear, you'll end up getting in custody and you'll be held. You understand that? Okay.
Yes, I understand.
All right, good luck to you, ma'am.
Thank you, Judge.
Thank you.
Next, we have Lynette Perez,
North Broward, I
North
believe.
Broward, thank you. All right, Ms. Perez, good morning. You have a possession of cocaine case and a possession of paraphernalia case. Your bond is set as $1,000. Mr. Reedy, do you want me to consider anything for her? Or is she
Yes,
able-
Judge, I spoke with Ms. Perez earlier. I don't believe she's going to be able to post a monetary bond on her own. She did provide me with the phone number for her father, but she doesn't know if her father's going to be able to bond her out either. I'd ask the court to consider pretrial release for Ms. Perez. She's been a resident here of South Florida all of her life. She stayed in the same location for the last 2 years. She has 4 children here locally. I know it's not her first contact with the criminal justice system, but based on her ties to the community, I believe she's a good candidate to return to court.
Mr. Linder, do you have a background for me?
Does pretrial have anything other than the arrest from last month that was dropped?
And are you asking for a reduction or a straight release?
I'm asking for a release without the condition of any monetary bond, Judge.
That's it?
If the court feels that a straight ROR is acceptable, that's fine. If the court would be more comfortable with pretrial release, Ms. Perez would be willing to go along with whatever conditions the court felt were appropriate.
I don't have an objection to pretrial, Your Honor. I would ask that random drug testing be a condition for release.
Okay. All right, I'll go ahead and consider pretrial release if she qualifies with an understanding that she would need to have drug screens. Otherwise, she would have to post a $500 bond. Okay? All right, so ma'am, they're gonna question you regarding potential pretrial release. If you qualify, they'll go ahead and release you without any money bond. I will require that you be tested, however, randomly for drug screens if you do go on pretrial release. Otherwise, if your family can post a $500 bond, you can get out that way. You understand?
I understand.
All right, good luck to you, ma'am.
Thank you.
All right, we're gonna call a couple of cases out of order. I have Mr. Shate here
Judge, I
for,
see that Ms. Sheehy, the first matter I put on there, has been a medical reset again.
okay, so page number 4, medical reset, Sheehy. Sorry, I don't know where these pages stop, so I just have to run through this paperwork. Apologize to make everyone wait. I'll have to pull that out later. Okay, so Underwood is the next one on page 12.
Yes, Judge.
Where's
He's in main jail.
main jail? Mr. Underwood, are you there? I need Mr. Underwood at the main jail, please.
He's approaching.
Thank you.
The lawyer's over there.
And he
That's
is
the one.
sentenced till May 17th.
Okay, so Mr. Underwood, my understanding is that, you've already been county sentenced till what, May?
May 17th.
17th, okay, and, I have an attorney here that I'm appointing to represent you on this charge. Mr. Shate, you want to, make any application to the court?
Yes, Judge, for the Deerfield matters, Deerfield Beach open container matters, he offered a time served plea.
So, sir, your attorney's asking that I consider a time served on the charge that's pending before me right now, which unfortunately, I can't find his paperwork. We gotta do something about this. He's on page 12. How many pages are in the docket, so I know where to look? 29, so somewhere in the middle? I just thought of a new thing I need to do is break these down into pages so I can find them. What's the charge, Mr. Shate? Okay. So, sir, are you?
Been 6 to
I can't hear you. I'm sorry.
He should have been about 6 or 7.
6 or 7 down from the top. Thank you. Here he is. Found him. Thank you. All right. So, sir, your attorney is requesting that I consider a time served on this. Are you interested in pleading out this case?
Ma'am,
Yeah.
I've been locked up since last year. That is not my charge.
This is not your charge?
No, that's my brother. I'm Isaiah. I've been locked up since October 17th, 18. That is not me.
Judge, if that's not that, I would just ask to be sent to the division for
Since he's got to stay in jail for a few more weeks anyway, and he doesn't want to plead this case out, we'll go ahead and just have him, sir, if this is not you, I'm not gonna have you plead out to a case that doesn't belong to you, so I'm gonna go ahead and, I'll just do this as an ROR in the event that his case doesn't come up before, in case this case doesn't come up before his release, and then he can come back to court. So, sir, if you wanna fight this, your next hearing date, you'll need to make sure that you're there if you're not released. Do you understand that?
But my question is,
Yes.
how can I have a charge when I've already been incarcerated?
Well,
Or open container?
unfortunately, I don't have the original date of the, if you want me to take a look at it right now, I'm happy to take a look at it right now. You'll have to have a seat for a moment.
Please take a look at that.
Isaiah, I'll speak with the city prosecutor and I'll have it resolved there, okay? So just allow us to call the city prosecutor's office in Deerfield and I'll take care of it that way, okay? So you probably won't even be brought to jail.
All
Only
right,
to
so,
court.
sir, what your lawyer is saying is that he can take care of it while you're still in custody before your release date, and he'll get the city prosecutor to just drop it if they can confirm that this date corresponds with the time that you were in custody, okay?
Well, when I came in here from work, they looked it up on the computer, and they already said that case was did this year.
Okay,
I'm saying, but
yes, ma'am.
I can't tell you her deceased number.
Stolen.
His number, which is the fingerprint, is not his.
It's not him. It's not you, sir. I'm gonna go ahead and dismiss this matter.
thank you.
Thank
Thank
you.
Good job, Isaiah.
This way.
You're a good lawyer, sir.
Thank you.
Yeah, it's a law degree.
Okay, case dismissed. All right, who's next? Mr. Turner on page 14?
Correct. Judge, the city of Fort Lauderdale is at their wits' end with Mr. Turner. They'd asked that this just keep the division date of Monday.
I was considering the same thing. So where is Mr. Turner? Which jail?
He should be at the main jail.
Main jail. Where's Mr. Turner?
He's coming, ma'am.
Thank you. Joe? Can you take care of the gentleman by the door, please?
You need to move.
Oh, okay, Mr. Turner, good morning. I have an attorney here that's going to be representing you in this matter. You have a hearing date set next week before your assigned judge. Your lawyer will be present in the courtroom at 9 o'clock so that they can talk to your assigned judge. In the meantime, I'm finding probable cause and I'm maintaining all the bonds. So we'll see you next week, okay, sir?
Yes,
Okay, all right, good luck to you, sir.
I believe,
You can leave now, yes, sir. And then last, I'm sorry, I can't read your writing, Mr. Shade. What's number 14? Number 14 was is it Howe?
It should be the next case, Judge, on, last name is Howe, correct,
Okay.
H-O-W-E.
Sorry, I couldn't read your handwriting.
It probably says Mao, M-O-W-E,
That's
right?
what it looked like.
Judge Diaz says the same thing.
All right, Mr. Terrence Howell. Where's Mr. Howell? What jail is Mr. Howell in?
Hey, jail, ma'am.
Thank you.
good morning, Your Honor.
Good morning, sir. How are you? I have 3 charges here, 3 KPSs, and a status hearing date scheduled next week with your assigned judge. Mr. Shade, anything on behalf of your client?
Judge, the city is gonna offer time served.
I can't hear you, I'm sorry.
The city will offer time served.
The city's going to be offering time served on this?
Correct.
Okay. Do we have someone representing the city here today, or just you've spoken to them?
Judge, yes, I've spoken to him.
Okay. So, sir, the city is willing to offer time served on all 3 of these charges. Are you willing to accept?
Yes.
Okay,
Yes,
sir.
Your Honor.
Will you please raise your right hand to be sworn? Do you solemnly swear or affirm any testimony you'll give this morning will be the truth?
Yes.
All right, put your hand down. Can you tell me your full name, please, sir?
Terrence Lee Howe.
All right, Mr. Howell, I have before me 3 charges. These 3 charges are public drunkenness, and carrying an open container, and public urination. The city believes that you have sufficiently been held on all 3 of these charges and offering a time served. Are you willing to plead no contest to this matter?
Yes, Your Honor.
All right, you understand by pleading no contest, you're not admitting anything, you're not denying anything, you believe it's just in your best interest to go ahead and resolve this matter here today. I'm gonna go ahead and accept your plea as knowingly and voluntarily entered. I'm gonna go ahead and adjudicate you on all 3 of these matters and sentence you to time served. Good luck to you, sir.
Thank you, Your Honor.
Thank you, Judge. Have a great weekend.
Thank you. Okay, so next I believe, I accidentally took someone out of the docket, so if I skip someone on the docket, please let me know. Lorenzo Sanchez, Alberto Lorenzo Sanchez.
He's approaching, Judge, here at me. Come on in,
Thank
sir.
you. Mr. Sanchez, Lorenzo Sanchez, sorry, good morning to you, sir. It appears that you have a out-of-state hold from the state of Kansas, so there's nothing I can really do for you today other than inform you of the fact that the state of Kansas wants you back in their custody. You'll be advised of all the information as to whether you wish to return to Kansas, and you'll be receiving the hearing date on a extradition warrant. So at this point, all I really can do for you is just let you know that you'll be held until we make a decision as to whether to send you back to Kansas or not. If you're willing to go back voluntarily, you can let them know that. Otherwise, you'll have a separate hearing, okay? All right, thank you, sir. Good luck to you. Did the gentleman that came in, was he our sign interpreter or no? Okay, all right. We're still waiting for the sign interpreter. Is Walter Kendrick next?
Here, present, Judge, at me. Come on
Okay.
up, Mr. Kendrick.
Mr. Kendrick.
He's approaching, Judge.
Mr. Kendrick, good morning. I have 5 charges actually, based on the affidavit that's been filed. There was a warrant for your arrest signed by a different judge, and that judge set your bonds. I've had an opportunity to review the affidavit to arrest. I do find probable cause, as well as the judge who originally reviewed the affidavit did find probable cause. Your bonds are as follows. Yes, sir.
On count 1, it's a punishable by life offense. Now, I understand Judge Casey set a $50,000 bond. There is nothing to indicate that he went beyond making a finding of probable cause, which is the standard for signing an arrest warrant. I'm going to be requesting that the court make a finding of proof evident or presumption great. Based on the statute and case law, if the court makes that finding, then Mr. Kendrick no longer has a constitutional right necessarily to bond. And I would be seeking, if the court makes that finding for first appearance purposes only, I would be seeking a no bond hold on that count.
Mr. Romero, your response?
I'll let my colleague, Mr. Reedy, take that.
Okay,
Judge.
Mr. Reedy?
Yes, Judge, we would ask that the court keep the current bond in place on count one. This matter has already been reviewed by another judge and felt that the $50,000 bond was appropriate. Proof evident presumption grade is the highest standard of proof that we have in the criminal justice system. I don't know that there was any more information provided to the judge who set the $50,000 bond that is currently before this court at this time. If there is no further information, then we would object to the court adjusting that bond and holding Mr. Kendrick without bond.
Well, I have to admit that when I was reading the arrest warrant, I was questioning why there was a bond on count one. And based on the information that the state is requesting, I am going to concur with them at this juncture and do find that that is a punishable by life, and that I do find proof evident presumption grade on that, so I am going to change that to a no bond hold, with the understanding that the assigned judge can always revisit that at an Arthur hearing. So I'm going to change count one to a no bond, and the other three counts will remain as $2,500, $2,500, $2,500, and then there's a traffic capias for $25. Sir, good luck to you.
And the only other thing
Oh, no victim contact.
Thank you.
Thank you, sorry about that. Sir, if, there's no bond hold right now, so I'm gonna go ahead and tell you, sir, that while you're in custody, you're not permitted to have anyone, any family members or friends have any contact with the victim, either directly or indirectly. You cannot have them send them any emails, text messages, try to call, write, anything along those lines. Do you understand that, sir?
Yes.
Okay, thank you.
Good luck, sir.
I took Samuel Knowles out of the paperwork by mistake. I don't know where they go, so if you let me know if I skip by mistake. We have Mr. Khan.
Mr. Khan is here present, Judge at Maine. He is approaching, and he declined the service as a public defender, Judge.
Okay, thank you.
Open wide.
Mr. Khan, good morning.
Good morning.
My understanding is that you don't want the assistance of the public defender. Do you have your own attorney?
No, ma'am.
Okay, do you want to represent yourself here this morning?
Yes, ma'am.
Okay, very good. You do have the right to have an attorney represent you at this and all hearings if you cannot afford an attorney. My understanding is, though, that you don't want the assistance of a public defender. You do have the right to represent yourself. However, understand that there is recording device going on right now, so I just inform you that anything you say can and will be used against you in the future, so please do not talk about the facts of the case. The only thing that we're here on today is what kind of bond I need to set for you. So the things that I'm going to be looking for are your ties to the community, whether you have a place to live, whether you work, and whether you can assure me that you'll come back to court and that you also abide by a no contact with the victim that I would be requiring as part of your release, as well as I would be requiring that you not have any alcohol or intoxicants while you're out of custody. So if I do release you, you're not allowed to drink, you're not allowed to do it. You understand that, yes? All right, so without telling me about the facts of the case, tell me a little bit about where you live and where you work. Do you have someplace to live?
I live with the victim.
Okay, well, that's not gonna happen for a while now, so I need
No,
to
of
find
course,
out.
I understand that.
Do you
but
have
this
a
is the
family
thing.
member or friend that you can go live with?
I could find somewhere to
Okay,
stay easily.
all right,
But
all
this is my thing, man. I suffer from bipolar disorder,
Okay,
and I haven't been on my medication for a little while because I haven't been able to get in contact with my doctor.
okay,
And
so,
I feel as though I should have been Baker acted,
okay.
but I don't know.
All right, do you work?
I work at a barbershop. I just got a job. I'm making a conscious effort to really turn my life around and head in the right direction. I haven't had any run-ins with any law enforcement.
Okay,
Legal-wise,
I'm gonna talk to the
in 4 years.
in 4 years. Okay, I'm gonna talk to the prosecutor and just confirm that. Not that I don't believe you. Let me just find out from the prosecutor.
Only thing is I've been Baker acted. That's it. It's just mental health issues.
Okay, all right. So
That's why I'm trying to get that resolved if I can today. Probably see if I can maybe get a bond or a pretrial release and try to get some mental health
okay,
help.
Mr. Linder, what's Mr. Khan's background?
Your Honor, and just so the court's aware, I'm going to be requesting a $15,000 bond and no victim contact. The reason being, one, the allegations in this case, which the court is familiar with. His criminal history. In 2012, 2015, he had a battery against his father. In that case, and I pulled the probable cause affidavit, it is alleged that he also threatened his mother, that he was going to stab her. He was arrested in 2015, the month before, for a battery against his mother, where there's allegations that he grabbed her around her neck from behind when she attempted to take a small plastic bag containing cannabis from his bed. That case ended up getting dropped, Your Honor. I believe his mother waived prosecution. He had a loitering and prowling in 2016. Obviously, my greatest concern is there's been 2 previous allegations, one that he pled out for violence against his parents. The one he pled out, there was an allegation of the same exact nature of what he's accused of standing before the court today, making threats with a knife.
And Mr. Khan, I see your hand up, and I understand that you may have some explanations for some of this, but this is my problem. My problem is that all I have is the information that I have in front of me right now. You're already telling me that you may not know where you have someplace to live. I think that this is better set before the judge that's assigned to your case, so they can talk to you in a little more detail as to where you can go and what you can do. And in the meantime, you can ask for some mental health assistance there while you're at the jail. But I agree with the state attorney. I'm gonna set your bond at $15,000 right now, okay?
15,000 is and the reason why I say this is because those that happened 4 years ago, and at that time I was very unstable with my medication.
Okay,
At that time.
I
And at
understand,
that time-
and I understand what you're saying, sir, but unfortunately, you don't have any assurances from me right now that you can get stable on your
of course,
medication.
Your
So I'm
course.
gonna leave it as is for now, but you can talk to your, you can talk to your
But I would-
assigned judge, because they've got more access to some of the mental health things that might be able to help you in the future, okay?
Of course. But
Okay.
I like the jail thing. Like the mental health in jail doesn't really work. It's just.
I understand that, sir, but I'm gonna leave it as is. You can talk to your assigned judge, okay? Good luck to you,
So I
sir.
can't have any contact with the victim.
No, sir, none
But
whatsoever.
that would be
No.
the only person who could help me with my bond. Is any way I can have somebody like a lawyer or somebody contact them, because I have no way to like do that.
Okay, well, you said that you don't want the help of the public defender, so you can either
He
hide.
didn't want to talk to me.
Okay. If you want to reconsider the assistance of the public defender, we can have someone else come out and talk to you at this time. Or if you can hire your own attorney, you can do that as well. But I can't permit you to have any contact with the victim at this time. Now, if the victim comes to us and says that they want to have contact with you, that's a different story. But right now, you're not to have any contact with the victim, okay?
Absolutely right,
All
Your
right,
Honor.
thank you, sir.
Ooh.
All right, is Parrish next? Can someone give me a copy of the docket, please? Is there an extra copy I can use?
He's approaching, Judge. He's here at Main.
Thank you. Thank you so much. And what page are we on right now?
11.
Okay, thank you. Excellent, thank you very much. All right, so we have Mr. Parrish, and Mr. Parrish is standing there, and Mr. Parrish has a charge of false imprisonment and a violation of injunction for protection of domestic violence. Irrespective of what I do regarding the bond, Mr. Parrish, you understand that you're not to have any contact, either directly or indirectly, with the victim in this case, both for the criminal case and the domestic violence injunction that's currently in place. Mr. Linder, what's the state's recommendation regarding Mr. Parrish?
Your Honor, I'm going to be requesting a $25,000 bond on count 1 and a $25,000 bond on count 2. The reason being is, Your Honor, the defendant is currently out on bond and pretrial. He's out on I believe it's a $10,000 bond for felony battery, second or subsequent conviction against the same alleged victim as in this case. I've been advised by pretrial that a warrant was prepared and I guess brought to Judge Allspector. It has not been signed as of yet.
He's out on bond, or he's?
Bond and pretrial.
And pretrial. Can't I just revoke the bond?
Absolutely.
Okay, I don't need to wait for Judge Allspector to do that. I
just wanted to provide the court with all the
No, I appreciate
information.
that. What's the case number on that one?
193687 CF 10A. Do you want to prepare an order for the judge? Yeah, Your Honor, pretrial's preparing an order for the
Okay, thank you. based on that, I don't know that we need to have any more conversations. I'm at this time sua sponte revoking the bond in case
I
number
understand that.
193687 CF10A. Yes, Mr. Romero, you were gonna say something?
Yes, Judge. Mr. Parrish wants me to address this one issue. Unfortunately, I haven't had an opportunity to review the PC report, but my understanding is from what Mr. Parrish advised me, he was actually arrested at his location where he resides. The victim came. Don't talk about the facts.
I'm not.
Okay, Judge, he's advised me that basically the victim came to seek him, not the other way around. Judge, by you revoking release and holding him no bond, that's the strictest form of pretrial detention this court can impose. I'd ask the court to consider a less alternative way, consider level 2 pretrial. And that's what I'm asking for, that the court not revoke his release.
Could I say something?
One moment, Judge.
He was, apparently he was already on a level 2, and again, I'm just looking at this as a snapshot. Even if what you're telling me is correct, and the victim allegedly went to his residence, at some point he let her in, which was a violation of what he was on bond for to begin with. So at this point, the only thing that I can do is what I think is correct, and you can always address this with Judge Alspector in the future, but at this point, I'm revoking the bond in the first count, and I'm putting a $20,000 bond on both of the other charges with a no victim contact. Thank you, everyone. Next on the docket is Webb. Paul Ryan, thank you. All right, Jeremiah Webb. Good morning, Mr. Webb.
Good morning.
We have a battery second offense, and am I correct that there's already, oh, I see, this is a change of charge, okay. So this is a change of charge. Originally, when Mr. Webb came through, he had a $10,000 bond on count 1 and a $5,000 on count 2?
Yes, Your Honor. When he first came through, count 2 was charged as a misdemeanor.
Misdemeanor.
Battery. I have no doubt that Judge, just based on my experience here, that Judge Powell was advised of his prior conviction. So I imagine she took that into account when she set the $5,000 bond. So I'd ask that the court, even though it's been upfiled, I'd ask that the court keep the bond at $5,000.
That's what I was planning on doing, so, Mr. Reedy, anything on behalf of your client?
Mr. Webb has a $10,000 bond on
On count
count
one.
1, so
Yes.
I think,
So, Mr. Webb, I'm just gonna leave everything as is. What you were brought here today to be told is that the misdemeanor charge that they originally charged you with for count 2 is now being upfiled to a felony. But I'm leaving the bonds as is. It's been upfiled because they're alleging that you've had a battery charge in the past, okay? So you'll have a hearing date with your assigned judge, and if you need to talk to about the assigned judge about your bond amounts, you can talk to them then, okay?
Yes, Your Honor.
All right, good luck to you, sir. I'm sorry, what? I'm leaving everything the way it was. Thank you. 5,000 with the whatever conditions were originally. I don't know what the conditions were. I didn't see that on the paperwork. I just saw the monetary bonds. All right, so that took care of Mr. Webb. Moving on to, my paperwork's out of order. I don't have a paperwork for a Pietro. Okay, all right, so we can move on to the next person then. Underwood? Okay, we took him already, that's right. Kirkman? Okay. Knowles, next is Knowles. Okay, where's,
Mr. Knowles is here at Maine, Judge.
thank you.
Mr. Knowles, come on up.
Come back up.
Knowles?
Mr. Knowles, your bond has been posted.
Oh, his bond was posted?
Yep,
We'll let
Mr.
him know. I believe he stepped out to the restroom, Judge.
Okay, his bond's been posted. I do find probable cause. His bond is at $25.
Thank you.
Thank you. Next, we have Michelson Durenay.
Michelson Journey.
Renee is your president.
Dumenay, sorry.
How do you pronounce your last name?
Dumarnay. I
All
tried.
right.
Morning, how are you? Nice to see you. Did the sign interpreter get here yet? No?
they're going to call
I
me
just
back.
I
They
wanna
have
make
one in
sure
the
someone
building.
tells me that they're here. I don't want them waiting.
No, I'll let
Okay.
you know as soon as they get here, but
All
they're
right,
gonna
thank you.
call me when they're sending him.
Okay.
There is one, I believe, in the building.
Okay, thank you. All right, we have possession of cannabis with a $100 bond.
That is correct, Judge.
Is he able to post that bond?
Judge, I'm going to see if the state has an objection with an ROR on this misdemeanor possession of cannabis.
Does the state
No.
have an objection?
No.
No? Okay, sir.
He's the minister.
The state has no objection to you being released on your own recognizance. Please understand that that means that you're gonna get a hearing date in the mail. If you fail to appear, the judge will issue a warrant for your arrest. So please make sure that you keep track of this and find out when your hearing date's going to be, but you can be released today, okay?
All right.
All right, good luck to you, sir. Next, we have, Moore,
North Broward, Your Honor.
North Broward. Thank you. All right, Mr. Moore, good morning. I have a charge of battery against you right now, and there's a $1,000 bond. I have had an opportunity to review the probable cause affidavit. I do find probable cause. Mr. Reedy, any presentation regarding the bond, or is he able to post it? Okay. All right, so, sir, I'm gonna maintain your $1,000 bond for you, and I'm finding probable cause. I also am warning you that you're not to have any contact with the victim in this case, either directly or indirectly, so no contact with the victim. Do you understand that, sir? Okay, is that a yes for the record? Yes out loud? All right, thank you, sir. All right, good luck to you. Okay, next we have Willie Frank. Willie Jr. Frank, where may I find Mr. Frank? Main jail?
Come on up, sir. Mr. Willie Frank is approaching, Judge.
Okay, Mr. Frank, good morning. I have a possession of cannabis charge and a resisting without violence. The possession of cannabis charge carries with it a $100 bond. Anything on behalf of your client, Mr. Romero?
Yes, Judge. After speaking with Mr. Frank, he wishes to resolve the matter. We wanted to know if the state had a plea offer for Mr. Frank.
He's currently on pretrial for a felony petty theft and a resist obstruct without violence. We're asking that you revoke it for case number 16009147 CF10A.
So unfortunately, Mr. Frank, you appear to have already been out on pretrial release on this matter, and I'm going to go ahead and revoke your pretrial release status because of this count. So, Mr. Romero, what do you suggest I do?
Judge, my understanding is, in speaking right now, Mr. Frank, he's been out on pretrial for 2 years. He's picked up a misdemeanor cannabis. I'm going to ask you, considering that he's been out on 2 years and this is misdemeanor cannabis, I'm going to ask you not to take any action on his pretrial release case, and I'll just ask you to leave the bond in place on the misdemeanor cannabis.
Just so the court's aware, there's more going on than just the felony pretrial case. It looks like he's out on a DUI. He's out on a no valid DL. I believe, and pretrial can confirm this for me, that all 3 cases are before Judge Porth in felony mental health court.
And Mr. Romero, I can appreciate what you're trying to tell me, but I believe that it's best served that at this juncture, given the new law violation, that not doing anything on the pretrial release would be the incorrect thing to do. So I'm revoking it. I'm just gonna set him with bonds on the other 2 counts and leave the 1 bond in place. So on his other 2 counts, I'm gonna put a $100 bond on count 1 and a $100 bond on count 2 of his 2016 case, and then he'll see his judge. And Judge Porth can make a decision as to how he wants to handle Mr. Frank's case. Does this go back to you?
Yes, ma'am.
I didn't date it.
It's okay.
Okay, next we have Jamal Patterson.
Judge,
Man, I'm tired of
Mr.
that.
Frank
Please,
wishes
sorry.
to address the court. I advise him, do not speak about the facts of the case.
I have to. Your Honor.
Yes, sir.
We have this felony, petty theft. It's been causing me some serious problems. I was arrested back in 1997 for a grand theft auto when a guy rented some guys a truck for drugs, a white guy. They came and got me. got caught behind the wheel. I came to court. The victim came to court and let the court know that a white man asked her for $3 and she told him she didn't have it. And he jumped in her car and he rolled off and she got ready to
Mr. Frank, hang on just a second. I know you want to talk to me, but this is the best that I can do for you, and I make you this promise. As soon as I finish this morning's docket, I will call Judge Porth's office, and I promise you that I will get you on his docket next week. Monday if I can, Tuesday the latest, so you can talk to him. But I don't know the background of your case, and he does, and that's the best I can do for you, sir. I promise you I will call him.
And I'll be in touch with Mr. Jakovich. I'll let him know about your situation as well, Mr. Frank.
What page is he on the docket? So
Page
I can
15.
Page 15. I'm gonna pull his case, and I'm gonna go talk to Judge Porth, and I promise you I'll get you on the docket. But that's the best I can do for you, sir.
This guy.
I can switch to another jail if you need a few minutes.
10 days ago, and that was for a grant that bond.
Mr. Frank, I can't do anything for you, I'm sorry. But I will call Judge Porth, and I'll get him to expedite a hearing date for him. Okay.
This is Mr. Patterson, Jamal Patterson, Judge.
Thank you, Mr. Patterson, good morning, sorry to delay your case. I have a petty theft, a petty theft, and giving a false name to a law enforcement officer. The petty theft is is a no charge, so there's no requiring for a bond amount on that, but there is a $100 bond on count 2. I do find probable cause. Mr. Romero, is he able to post that $100 bond?
He's wishing to see if the court's willing to resolve this matter today, Judge.
Your Honor, the state does not have an offer at this time. Actually, even though a bond is not required on count 1, the state is going to be requesting a $500 bond. Mr. Patterson was arrested 10 days ago for grand theft auto and posted a $1,000 bond. In 2017, he was convicted of grand theft auto and burglary of a conveyance and theft in 2 separate cases, sentenced to 364 days.
Okay,
county jail.
wait, slow down. Let's go back to the grand theft case you're telling me about 10 days ago. He's got a bond on that?
Yes, $1,000 bond.
And when was the incident that occurred there, was previous to this one?
Yes, he was arrested April 15th.
Okay. I'm gonna go ahead and adopt your recommendation for the $500 on count 1, and I'm going to go ahead and revoke his bond in the grand theft auto case.
For the record, that case number is 194875.
194875.
CF10A, and I will prepare an order for the court.
Okay, Mr. Romero, you can explain that to your client. Next case is Juan Sebastian Mera Garcia.
He's approaching Judge here at me. Come on up,
Thank
Mr.
you.
Mera Garcia.
Okay,
Good morning.
Good morning, sir. You have a charge of stalking, follow, and harassing. I do find probable cause based on the the arrest affidavit. What's the state's recommendation regarding a bond, please?
Your Honor, with respect to this matter, I have concerns for the victim's safety and well-being. I'm requesting a $15,000 bond, pretrial release with a GPS monitor, no victim contact. I would also advise the court, Mr. Mera Garcia is currently out on a $1,000 bond for possession of THC, misdemeanor possession of cannabis, and possession of drug paraphernalia before Judge McCarthy.
Okay. And what's the case number on that, please?
18352 CF10A.
All right, sir, based on the information that the state's provided me, I'm going to go ahead at this time and revoke your bond on case number 1813352. Have you held no bond on that one? In the event that Judge McCarthy changes my decision on that and gives you a bond, in this matter, I'm going to adopt this recommendation of the state. Place a $15,000 bond on count 1, also with GPS monitoring in the event that you're able to post that bond. Sir, I am warning you at this time, and I'm going to need a verbal affirmation that you understand that you're not to have any contact with this victim, either directly or indirectly. You're not permitted to go back to the house. You're not permitted to send text messages, emails, telephone calls, have someone go to the house, or anything along those lines. Do you understand that, sir?
I understand that, Your Honor. I got served yesterday. I understand all the things.
Okay.
Trust me, this is all a misunderstanding. If I could please just get to resolving this case from the outside.
And your lawyers will help you do that. I'm not making any determinations of whether this information is true or not true. I just have to go ahead and go by the paperwork we have. If you can explain to your lawyer why this is a misunderstanding, I'm sure they'll be able to help you, but you'll have to go to the assigned judge. Good luck to you, sir. All right, next we have Edison Gomez. Not in custody? Okay. There was a medical reset. Someone post the bond? Okay, all right. Next, we have Plummer. Mr. Plummer?
He's approaching, Judge.
Thank you. Good morning, Mr. Plummer. I have a this was an ad charge, so it appears that you've already been through the system. They ad charged a fleeing attempt to elude a law enforcement officer. This would be count 5 of your case. You do have a hearing scheduled with your assigned judge next week, and this new charge carries with it a $1,000 bond. So there's not much we're going to do today other just inform you that you've got one more charge on this case, okay?
Okay.
All right, thank you, sir. All right. Next, we have Joel Russell, is it Valley?
He's in downtown court, Your Honor.
He's in court? Okay,
Yes, ma'am.
I see. This was an ad charge. So if it needs to be reset, y'all will reset it.
From what I can tell.
Thank you. Next, we have George Moore. Where's Mr. Moore?
Conti, Your Honor.
Okay, Mr. Moore, good morning, sir.
Good morning, ma'am.
It looks like you've already been through first appearance court, and you have some other charges pending. I want to let you know there's really not much I'm going to do for you today to change anything other than let you know that they're actually adding another charge to your case.
I see.
And
Can I
there's
say?
hang on just a second. They're adding us selling cocaine and carries with that a $1,500 bond. I suggest that you not say anything about the case and that you just let the lawyer either talk to you by the phone, or if you have a question about your bond or your charge, I'm happy to talk to you about that. But please don't tell me anything about the facts of the case. Do you have a question for me?
Yes, I wanted to say about that. How could I get seal out of paraphernalia?
I would not be saying anything else
Okay,
if I were you, Mr. Moore.
yeah, sir,
You're already being held no bond on other capiases.
Okay.
Everything you say is being taken down. You don't need to put yourself at the scene of the
Okay,
incident.
Sir, just at this point, the charge is what it is. You're being held on other charges as well. It doesn't appear that this one's going to make much of a difference on your bond status right now, so please listen to your lawyer and don't talk about the facts of the case, okay? I'm not going to talk about try to explain to you why they're charging you what they're charging you with, okay? So good luck to you, sir. Next, we have Mr. Barry Williams.
North Broward, Your Honor.
Thank you. Switching over to North Broward. Mr. Williams, good morning, sir. It looks like you have some ad charges as well, so I don't think we're going to be doing anything different to your case right now other than to just let you know that now they're adding a charge 5 and 6. Charge number 5, count number 5 is a grand theft. It carries with it an extra $1,000 bond. And count 6 is a petty theft, and it carries with it a $750 bond. You should be getting a court hearing date coming up shortly, and those are the additions to your current bond right now, okay? All right, good luck to you, sir.
Is there any way that I can get a bond reduction?
Not today, sir, no. All right, we have, is it Mr. Brownlee? Where's
Judge,
Mr.
I've been in regular court.
Mr. Brownlee's in regular court, okay?
Correct, Judge.
Okay, that's why I shouldn't do these at a time. All right, so this is reset it if you all need to. Next, we have Odessa Sider.
He's here, President Judge.
Thank you.
President Court.
This one's another one I was questioning why there was an actual bond on. Mr. Sider, you have 2 charges pending against you right now, an attempted felony murder and a robbery with a firearm. The arrest warrant set bonds, however, I believe that the prosecutor has something to tell me.
It's actually, Your Honor, Mr. Sider's Ms. West co-defendant, who you heard her case earlier this morning.
Okay.
Proof evident, presumption great. I am going to be asking the court to make a finding of proof evident or presumption great on these charges. These are both punishable by life offenses. There's nothing to indicate the judge signing the arrest warrant made that finding. If the court is inclined to make that finding, then Mr. Sider would no longer be constitutionally entitled to a bond, and the state would ask that he be held no bond.
And we would object to the court disturbing the bond that's already been put in place for Mr. Sider, just as we made the same argument on behalf of Ms. West. Proof beyond a reasonable, proof evident presumption great is the highest burden of proof that we have in the criminal justice system. And then the state has only introduced an affidavit, called no witnesses, introduced no physical evidence, and done basically the bare minimum to try and establish that standard. So we would ask the court to set bond for Mr. Sider. In the alternative, if the court, over our objection, does find proof evident presumption great, we would then ask the court to exercise its discretion and set bond for Mr. Sider.
Right. Thank you for your presentation. I do find at this time that there's sufficient information to have me find proof evident presumption great. I am going to hold Mr. Sider no bond pending his hearing date before his assigned judge. And I am going to require that Mr. Sider have no contact, either directly or indirectly, with the alleged victim in this case. And obviously, the assigned judge, if requested by Mr. Sider's attorney, can conduct an Arthur hearing. At that time, more information can be given as to Mr. Sider's contact with prior history, his ties to the community, and whether the judge wishes to set a bond in this matter. Good luck to you, sir. Next, we have Richard Thomas.
Mr. Thomas is here, approaching, Judge. Come on up, sir.
Mr. Thomas, where is Mr. Thomas? He's coming.
He's approaching. Yeah.
Thank you.
The way the new layout
I
is.
know, I understand. Mr. Thomas, good morning. I have paperwork here in front of me showing that you've been charged with the possession of MDMA, which is also known as ecstasy, and drug paraphernalia. Your charge 1 comes a $1,000 bond. I've had an opportunity to review the probable cause affidavit. I do find probable cause. Anything on behalf of your client? No?
Nothing to add at this time, Judge.
All right, very good. I'll maintain the $1,000 bond. Good luck to you, sir. Next, we have Lewis Clark.
Mr. Clark is approaching. He's here at Maine, and Judge, we're going to be waiving formal reading of the charges.
Thank you, sir. State have a recommendation regarding the bond amount in this matter?
Yes, Your Honor, just one moment. Your Honor, I want to first advise the court. Mr. Clark has, from what I can tell, no criminal history. The state's recommendation is based solely on the allegations, the strength of the evidence, and concern for the victims and safety of particularly minors in the community. Your Honor, I'm going to be requesting on counts 1 and 2, $25,000 bonds each. On counts 3 through 23, $50,000 bonds each. On counts 24 and 25, $25,000 bonds each. I'm going to be requesting additional release conditions in addition to whatever bond the court deems appropriate. Pretrial release with a GPS monitor, level 1. No victim contact with either alleged victim. No contact with any minors. And that Mr. Clark not be in possession of any video recording devices.
Mr. Romero, anything on behalf of your client, or are you planning on just letting me decide?
Judge, I understand as far as the state's concerned. We don't have any objection as far as their pretrial recommendations, as far as the restrictions. However, I'm going to be focusing on the monetary bond. I'm going to be requesting a $5,000 bond on counts 1 and 2 through 3 through 22. I'm going to be requesting a $10,000 bond, and on counts 23, I'll be requesting a $5,000 bond, and on counts 24 and 25, I'm going to be requesting a $10,000 bond on each one of those. And speed, as you heard, this is his first contact with the criminal justice system. He lives in Pembroke Pines. He owns property, owns his house. His monthly mortgage of approximately $2,653. He's been living there for about 12 years. He does own a car. It's a Toyota Tundra 2005 with approximately 300,000 miles on it. He's 38 years old, and he works in construction, where on a very good day he can make up to about $500 per day. I understand the allegations with all the other pretrial, recommendations that the state has given. I would say that would assure the safety of the community. Therefore, the monetary amount that the state is suggesting would be tantamount to no bond. So that's why I made my recommendations, to see if hopefully his family, his friends, anyone can come up with that monetary amount, and that is the basis of my recommendation, Judge.
Thank you so much. I'm going to go ahead at this time, and regarding the non-monetary portion of the recommendations of the state, I'm going to go ahead and adopt those recommendations at this time. Also going to advise Mr. Clark that he's to have no contact with either the victims in this matter, either directly or indirectly through your family or your friends, no text messages, telephone calls, emails, anything along those lines. Also, I do agree with the state that he's not to have any contact with any other minors while the case is pending. I'm going to go ahead and set a $100,000 bond on count 1, a $100,000 bond on count 2, and $20,000 on all the remaining counts. Good luck to you, sir. Next, we have Moses Hope
That's PC.
with GPS, yes.
Sure. I've been advised is in regular court, Judge.
Regular court. Okay, very good. Next, we have Carrie Lewis.
Mr. Willis is approaching, Judge.
Did I say Willis? I said, yeah, Willis. Carrie Willis, right?
Yes, Judge.
Okay, sorry. I thought I heard you say Lewis.
Willis.
All right, Mr. Willis, you have 2 charges of an aggravated assault with a deadly weapon without intent to kill. I need to make a determination as to the bond. Can the state tell me a little bit about Mr. Willis's background, please?
One moment, Your Honor.
This is a warrant with no determinations on the bond, right? It
That
says
is-
no bond.
It's no bond, but to be set at first appearance.
Okay,
yeah.
thank you. All right.
Yes, Your Honor, I can tell you, I'm looking up his history. The affidavit makes reference to, law enforcement made contact with Mr. Willis at a later date and found him in possession of a firearm. Those charges were filed: carrying concealed firearm and felony possession of cannabis. Obviously, this would not be a violation of his release conditions because this occurred prior to his arrest.
Yes.
As far as, let's see.
Are you seeing a history or no?
I am. There's a lot here in CCIS. I just need to make sure that it's not all traffic. I'm showing an open criminal mischief out of Dade County right now.
What's the state's recommendation, please?
Your Honor, based on the allegations in the case threatening with a firearm, I'm going to be requesting a $20,000 bond on each count, pretrial release with a GPS monitor, no victim contact, and order that Mr. Willis not be in possession of any firearms or weapons until further order of the court.
I was actually considering a $25,000 bond, but Mr. Romero, you have anything you want to let me know regarding Mr. Willis's ties to the community?
Yes, Judge. I mean, 20 or 25,000, that's going to be something impossible for Mr. Willis. As you heard, basically has a limited contact with the criminal justice system. He is a registered voter in our community. He lives with mother, and his mother's going to be the person that's going to help post his monetary bond, but she's retired on Social Security. So as you can see, he has very limited funds, and he just started working at a company called Dream Vacations, where he's a travel agent. He hasn't even received his first paycheck yet. I'm going to ask you to take that into consideration in determining a reasonable bond for Mr. Willis.
Thank you for his background. Unfortunately, I do find, based on the circumstances of this particular case, that a $25,000 bond on each count is warranted. Also, sir, you're to have no contact with the victims, either directly or indirectly, or with your, through your family or friends. No telephone calls, text messages, anything of that nature. Good luck to you, sir. Next, we have Brian,
Your Honor, our sign language interpreter is present.
I'm sorry? Yes. I forgot to put that on here.
Yeah, that's not what you're gonna do in the weekend for today's purpose.
I'm sorry, Brian Valdiva?
Mr. Valdiva's parents are present, Your Honor.
Oh, thank you. Where are they? Oh, right there.
You're present, Judge?
All right. My understanding is that he has a private attorney. Is that correct?
I spoke with the attorney's office. They have not yet been retained.
Okay, they haven't been retained. Okay. All right, so,
They cannot attend this morning, so Mr. Valvita will be represented by the public defender's
all right,
office.
very good then.
And I'm ready to proceed, Judge.
Okay, thank you. Folks, I'm also happy to hear from you all if you like. You're welcome to come to the podium if you want to. You don't have to speak to me if you don't want to speak to me. We're just going to be determining your son's bond here this morning. So if I could hear from the state first, please.
Your Honor, I need to put his information in the system to see if there's any juvenile history. I don't know if you want to, if Mr. Romero wants to provide any information while I'm doing that to the court.
Okay, so actually, yes, Mr. Romero, you want to let me know anything, and then I'll speak to Mr. Valdia's father?
Judge, my understanding is this is his first contact with the criminal justice system. He's 18 years old. He's born here, been here his whole entire life. He's a senior at Everglades High School. Because of this, most likely, Broward County School Board is probably going to be sending him to another facility. But his GPA is 2.1. He took the SATs. He wants to go to college. He didn't do so well. He only got 20. He plans on
I start school at Barry for
Okay.
next month.
Okay.
Just in a couple weeks.
Oh, okay. Judge, he lives with his parents and his younger siblings. My understanding is his father is going to be the person that's going to be helping to post his monetary bond. I do not know his father's financial resources, so I do not know what the family can afford to post as far as Mr. Valdivia is concerned, but I'm going to be asking you to take that into account. Besides going to school, he works part-time at Pizza Hut, so he is working and going to school.
All right, thank you. So, sir, I'm going to be asking you a couple questions here real soon. First, I'm going to get your name for the record. Please, whatever you do, do not discuss anything regarding what you think may have happened regarding your son's case. That's not what we're here for today. I just need to make a determination as to whether you can assure that your son will come back to court, and whether you'll keep an eye on him, and whether we'll make sure that he doesn't get into any more trouble between now and his next hearing date. So I'm going to ask you to please raise your right hand to be sworn. Do you solemnly swear or affirm any testimony you give this morning will be the truth? All right, thank you, sir. Will you put your hand down and please state your full name for the record?
My name is Martin Valdivia.
All right, and you'll need to speak up just a little bit so we make sure that
My
your
name
son's...
is Martin Valdivia.
All right, Mr. Valdivia, this is your son, yes?
Yes, it's my
And does
son.
he reside with you?
Yes.
Okay, and I can see from my own search of the court records, it doesn't appear that he's ever had any trouble here in the past here in Broward County. Do you believe that you can ensure that he comes to court for his next hearing date?
Absolutely.
And assure...
He's an excellent student.
Okay,
He's, as a matter of fact, he's in the academy to go into firefighting. He's been 2 years, pursuing this. He's in college right now. He's working. He's all week. He's, busy all the time.
okay, all right. And does he come home at a regular time? Does he listen to you? He listens to his mother? He
He
doesn't...
stay until 3 o'clock in the morning doing homework because he get up for work at 1 o'clock in the morning. He gets home, start doing his homework, and the next day at 6 o'clock, you gotta get ready to go.
Okay, all right. And can you afford anything in order to post a bond to make sure that he comes back to court? Can you post $1,000 bond or a $100 bond, or what are your finances?
Not really. My finances are like, living day by day.
Okay, and is that one of the reasons why he works, is to help with the family?
Yes.
Does he contribute to your household?
Absolutely, yes.
Okay, all right.
I got 4 kids, 4 boys.
Okay, and are they older or younger than him?
The other two are younger than him.
Younger than him?
The older is in college,
Okay,
and he's the one second going, to college as well.
okay, all right, very good. Mr. Linder, what's your recommendation?
Your Honor, as far as bond amount, I'll leave that in the court's discretion. The only request I would be making, frankly, is one, obviously, that Mr. Valdivia not be in possession of any weapons of any type or firearms. I'm also going to be asking at this point in time no return to the campus of Everglades High School until further order of the court.
Sir, do you have any firearms in your household?
No.
Okay.
We don't carry that kind of stuff. We don't,
Okay,
we don't
okay,
do that.
all right, just
The
wanted
only
to
thing
make.
that, this material was from his
Oh,
job.
wait, don't say,
Okay, I'm sorry.
don't say anything, don't say anything. Okay, all right, I'm going to go ahead and based on the fact that it appears that he has a very significant ties to his family and that he has family support, he has no background whatsoever in Broward County, and he appears to, at this juncture, not pose a danger or a threat to the community. Have you ever seen your son make any kind of allegations regarding hurting anyone or doing
Not
anything?
violent at all.
None at all?
At all. Not even verbally.
Okay, all right,
We
he's,
go to church on Sundays. I mean,
okay, all right, I'm gonna go ahead then at this time, and, I would like to, however, release him on pretrial release, but I will not require a bond. So, sir, the pretrial release people are going to be, talking to you, they're gonna put him on supervision prior, once he's released from custody. So I'll have to report regularly, make sure that they always know where he is. I'll permit him to continue to go to work. He's not permitted to go back to the school that he was alleged to have this weapon at whatsoever. So whatever arrangements you all need to make for his schooling, there's gonna have to do something completely different as to what this school is. He's not permitted to go back there at all, go near there, anything like that. Do you understand that? And not only do I need to make sure your father understands that, but Mr. Padilla, you need to understand, Brian Padilla, you need to understand you're not permitted to go back to this. You're not permitted to have any weapons of any kinds. That includes a pocket knife, a mace, anything along those lines. Do you understand that, sir?
Yes.
Okay.
And Judge, I am giving
Hang on
him
just
the
a
map
second.
to
I'm sorry.
pretrial.
Hold on just a second. The pretrial folks were asking me a question. I don't think we're necessary for a GPS standard. It would be fine. The state's agreeing with me that he
And,
doesn't
Your
need
Honor,
it.
and I can confirm, I checked, he has no juvenile history.
I looked too. He has no
Yeah.
juveniles. Okay, so I'm gonna go ahead and release him on standard pretrial release with the understanding that he have no weapons. And, I'm gonna beg the parents to make sure you keep an eye on him, make sure no knives, no pocket knives, no anything. Anything like that in your household, you need to lock up and put away, okay?
yes, Your Honor.
Okay, thank you. Thank you for being here.
And Judge, I am giving him a copy of the map as far as how to locate pretrial. If, depending on what time he gets out today, I know pretrial is closed over the weekend, so if they're closed, he would have to report by Monday morning, correct?
That's correct.
Thank you.
Okay, so make sure he reports immediately upon being released. If it's too late today, then he has to be there first thing Monday morning, okay? He's gonna get released. He's gonna have the map of where they need to go. So when you pick him up from the jail, when they release him, he'll have the information that you need, and you need to make sure that he gets signed up with pretrial. If they're still open today, do it today. If they're not open today, first thing on Monday, okay? I'm sorry? I understand that, sir, and that's a good thing, because if he had a record, we wouldn't be talking about this right now. So do your best to make sure he stays out of trouble, okay?
Your Honor, our sign interpreter is present.
Oh, wonderful. Where's our sign interpreter?
He's right there.
Hello, sir. Good morning. If I could please ask you to raise your right hand. Do you solemnly swear or affirm that you will, to the best of your ability, provide translation for us for sign purposes for a person with a hearing impairment? All right, thank you. Can you please state your name for the record?
Keith Muller, M-U-L-L-E-R.
All right, thank you. We're going to go back to Miss Brenda Ambrose. Now, I'm not sure, you may have to come in front of me to be able to have her see you. Northbound. Okay, why didn't you come up here, sir? You can just stand right in front of me. I believe she should be able to see you. Yes, okay, and can you see that screen there behind you?
I can see you.
Yeah. Sir, right, I think the best thing to do is stand right in front of me. There you go. And, okay, good. All right, ma'am, please let us know if during our conversation you cannot understand the sign interpreter, or if his hands drop too low so you can't see what he's saying. All right, we are here on a charge of battery on a officer. This is an ad charge. Miss Ambrose was before the court previously, and she has some other charges pending. And the police officers are stating that while in custody, she unlawfully touched or struck a corrections officer. We're going to be adding an additional monetary bond to your case. I'm going to be hearing from the state first as to what the bonds are on the rest of your case and seeing if they wish for me to add an additional bond for this matter. Mr. Linder?
Thank you, Judge. Your Honor, I would be recommending a $1,500 bond on this count. Ms. Ambrose is being held no bond on the other 3 counts. There was a violation of pretrial warrant signed by Judge Porth, holding her no bond on charges of strong-arm robbery, battery on a law enforcement officer, and criminal mischief.
Criminal mischief.
Criminal mischief, sorry.
I understand, ma'am. They're saying that you touched or hit someone, one of the officers there in the jail. Given what the information that the state attorney has given me, I'm just going to add a $100 bond to this amount and leave it at that.
That's fine, Judge.
The rest of your case, ma'am, unfortunately, this additional charge really doesn't impact what's happening with you. So I'm just going to put a low bond amount on this. So you'll be talking to your assigned judge regarding your other charges, which are a lot more of a problem right now than this particular charge is, okay? Sorry to make you wait so long this morning, but we needed the interpreter to come so that we could speak with you, okay? Good luck to you, ma'am.
So Miss Ambrose knows the allegation is that she spit at the deputy.
Sorry, thank you. All right, we're done. Thank you. Thank you. Yes, sir, absolutely, absolutely. All right, next we have Daniel Brown. Where's Mr. Brown? Thank you so much. That's not
Mr.
me.
Brown is that main judge?
There we go, okay.
Second case.
Thank you. You've been busy this morning. Thank you. Okay, main jail, thank you. All right, Daniel Brown. Mr. Brown, there doesn't appear to be much I can do for you this morning. There is a violation of probation that's pending against you right now that you're being held no bond on based on the determination of your assigned judge. You do, however, have a court hearing on Monday at 8:30, and you can speak to your assigned judge at that time to see whether they're interested in resolving the case or releasing you on a bond, okay?
All right, good luck.
All right, good luck to you, sir. All right, next we have Randall Opie.
He's approaching, Judge, here at me.
Okay. Mr. Opie, good morning. I have had an opportunity to review your probable cause affidavit. I do find probable cause for the charge of distribution and/or delivery of heroin. It carries with it a $2,500 bond. Anything on behalf of Mr. Opie, Mr. Romero?
Yes, Judge, she asked me to ask the court if the court would consider releasing him on pretrial release, and unfortunately he's financially indigent and he is homeless, and there's no one that can afford to post his monetary bond.
What type of a background does Mr. Opie have?
His most recent prior, last year, was convicted of and sentenced to 15-month state prison on an attempted burglary of a dwelling. He was just released from state prison April 1st.
Unfortunately, Mr. Romero, I'm not willing to consider that. Mr. Opie, I'm going to maintain the bond as is. You are always welcome to talk to your assigned judge regarding changing that. At this point, I'm going to leave it as is. Good luck to you, sir. Next, we have Mr. Carter, Jamar Carter.
Jamal Carter, come on up.
Mr. Carter, good morning. There's not much I'm going to be able to do for you today because you do have an out-of-county hold from Miami-Dade, which has a $7,500 bond on that one. I'm not going to disturb that one. That was set by the Miami-Dade judge. You do also have new charges of a grand theft and a KPS on a traffic matter. The grand theft carries with a $1,000 bond, and the KPS on the traffic a $500 bond. I do find probable cause. Ms. Romero, anything? Oh, wait, hang on, I'm sorry, yes?
He's currently on pretrial for 2 other cases. One is a grand theft auto and driving with suspended license. The other one is the grand theft in the 3rd degree. Case number 19657 CF10A and case number 191347 CF10A. We're asking that you revoke his pretrial.
Okay,
He was placed on January 15th and March 9th.
okay. Mr. Romero, anything on behalf of your client?
Right now, nothing, Judge.
Okay, not only am I revoking his pretrial release, but, had he been on a monetary bond, I would be inclined to revoke his his monetary bond as well. So in case number, 191347 and 19657, I'm gonna go ahead and revoke the pretrial and hold him no bond and maintain the other bonds as is. Good luck to you, sir. Next, we have Cody Lawson.
He's approaching, Judge.
Thank you.
Good morning, Your Honor. How are you?
Good, thank you. Mr. Lawson, I have here a possession of cannabis and operating a vehicle in unsafe, improper equipment. That doesn't have a bond, obviously, but we do have a $1,000 bond on the possession of cannabis.
Your Honor, he's currently on pretrial for possession of cannabis in an 18 case, 1810856 CF10A. We're asking that you revoke his pretrial in that case as well.
Okay, I am going to revoke the pretrial, so I need to determine what my bond should be in both of them. Mr. Lawson now has 2 charges pending, 2 cases pending for the same charge. There's a $1,000 bond on the other cannabis charge. Mr. Romero, is your client able to post a bond?
Nothing to add from the defense, Judge.
All right, thank you. I'm going to go ahead and maintain the $1,000 bond on the new charge and institute a monetary bond on the other one of $1,000, revoking his pretrial release. Next, we have Antonio McCray.
North Broward is requesting that Mr. McCrae's case be reset for the afternoon docket, Your Honor.
Okay, you want to reset for this afternoon, yes?
Yes, please.
Yes, please.
All right, we will do that. We'll see you this afternoon. I'll maintain the paperwork right here.
Thank you.
Thank you. Next, we have Anton Brand.
Mr. Brand, come on up, please.
All right. Mr. Brand's at main jail. There we are. There he is. Okay. Good morning, Mr. Brand. We have 2 count charges against you right now. One is possession of a weapon or ammunition by a convicted felon. The other is possession of cannabis. I need to make a determination as to charge 1. I do find probable cause. What's the state's position regarding his bond and what are his background?
One moment, Your Honor.
Thank you. Mr. Romero, you want to tell me a little bit about Mr. Brand's ties to the community while we're waiting, or what he might be able to afford?
Judge, I'm going to be asking for a $2,000 bond on Mr. Brand. My understanding, he does have contact with the system, but in speaking with Mr. Brand, it's been quite a while since he had contact, about 10 years. He's 41 years old, been living in South Florida since 2008. He works on and off in landscaping, and on a good day, depending on the weather, he can make up to $100 a day. Now, he's going to be reaching out to his mom to help him post a monetary bond. She works at a hotel. So if the court finds a set of $2,000, his mother, using the services of a bondsman, may be able to post his bond. And one thing, in speaking to Mr. Brand, he is looking forward to contesting these allegations. My understanding is that 1 bullet was found in the premises in which That premises is shared by other occupants. So Judge, he's looking forward to having his day in court.
Thank you.
Just for the record, and I know the court's aware of this, there was a lot more than one bullet found there. Over 257 rounds of assorted ammunition were found. Your Honor, I'd be requesting a $5,000 bond. Candidly, his last felony conviction was a sale or delivery of cocaine out of Manatee County in '04. Going through his history, though, I also see numerous prior failures to appear.
All right, anything else, Mr. Romero?
Not at this time, Judge.
I'll go ahead and adopt the state's recommendation. I was actually considering more, but given the fact that it doesn't appear that he's gotten into trouble since that last time, and that the ties to the community that you're telling me about, I'm going to go ahead and adopt the state's recommendation of the $5,000 bond. Thank you. Good luck to you, sir. Next, we have Alexander Bucknor.
Mr. Bucknor, come on up, please. Please approach and Judge.
Thank you. So am I reading this? I'm not sure if I'm reading this correctly. On the face sheet here, it has 4 different counts, and then it has case numbers listed on count 3 and 4. Are there 2 separate case numbers, or is this all one case number?
Yeah,
Oh, okay. So it's just referencing the arrest warrant case number, but it's all one case?
No, it'll
No?
be counts 1 and 2 will be one case. Charges 3 and 4 will be a second case.
Okay, all right, understood. But he's being arrested for the first time on all of them?
Yes.
Okay, all right, very good. And what's the state, right now? All right, so, sir, I just wanted to make sure I was reading everything correctly. So right now, you're being charged with possession with intent, possession of cannabis. The possession is with delivery of cocaine. Then there's a selling cocaine within 1,000 feet of a school and another delivery of cocaine. So for four complete charges, we have $2,500 set bond on count 1. Nothing necessary on count 2, $25,000 bond on count 3, and a $7,500 bond on count 4. State wish for me to maintain these bonds as is?
I'm going to ask that, Your Honor, keep the bonds in place and also keep the special release conditions that Judge Usan ordered in place. Your Honor, I just want to advise the court.
And what were those conditions? I didn't see that.
One moment.
Oh, I see them now, okay. Special conditions, proof of funds not being used for bail or tainted by illegal activity, surrender passport, okay, I see those, yes, sir.
And Your Honor, additionally, Mr. Buckner was arrested March 22nd of this year for trafficking cocaine and possession of cannabis with intent to sell or deliver. He was released on March 23rd after posting bond in the amount of $16,000. I would note, according to obviously the new charges would violate his release conditions, and also the second allegation in the arrest warrant affidavit that allegedly occurred on April 5th of this year would
Okay.
also violate those release conditions.
I was just about to say, because some of them seem to predate the March, but we have the one of April 5th, yes?
That would, and also the new possession with intent to deliver when they executed the search warrant on his home.
And what was that case number?
The case he's out on is 193839 CF10A.
All right, sir, based on the fact that it appears that you were out on bond and a condition of your bond is to not have any new law violations, I'm going to go ahead at this time and revoke your bond in case number 193839 CF10A, and I'm going to maintain the bonds that are currently in place as is. You can talk to your assigned judge regarding the revoking of the bond that I'm discussing right now. Good luck to you, sir.
Your Honor?
Yes, ma'am, what else?
The AF warrant, it doesn't have a level for the GPS. Do you want to set a level?
What's the highest level?
Level other one is complete restriction.
That's fine. Okay. All right. Next we have Brian Laverty. Where's Brian Laverty?
He's approaching, Judge. He's here.
Thank you.
Your Honor, if I could be heard before the court makes a PC determination.
All right.
I know.
All right, good morning, Mr. Laverty. We are currently being charged with the burglary of an occupied structure unarmed. The state attorney wants me to consider something. Go ahead, sir.
Your Honor, I know on the PC affidavit and booking sheet, it states a structure, but it would appear from the allegations that this was a dwelling.
Okay. And I apologize, my paperwork came late this morning. I haven't had a chance to review Mr. Laverty's probable cause affidavit, if you'll give me just a moment. All right, we're back on the record. I've had an opportunity to review it. It appears that the state is correct. It's obvious from the narrative of the probable cause affidavit that this was a alleged dwelling that's involved in this matter. What's the state's recommendation at this time? And is this going to cause us to have to refile paperwork and fix this, or
what'll happen, what I would ask the court to do
Yes.
is if you could just, you don't have to cross anything out. I know the jail hates that. If you could just write in dwelling.
Okay.
What'll happen is, assuming we file charges as on a burglary of a dwelling, it'll come back as a change of charge KPS.
Okay.
But obviously, the court can refer to Your Honor's findings today to see that you did make a finding for burglary of a dwelling. Your Honor, I am concerned about these allegations, not just the allegations that he stands before the court on today, but also it's noted that a security personnel at this building mentioned that, a similar incident occurred last year involving Mr. Laverty, but a different apartment that was occupied. His explanation innocent explanation for why he was in that apartment does not coincide with the facts, the physical facts, and it causes greater concern. Mr. Laverty's currently on probation out of the state of Georgia, from what I can tell, for DUI. He was placed on 12 months of mail-in probation on June 7th of last year. I don't see any other priors. I'm going to be requesting a $25,000 bond, pretrial release with a GPS monitor, that he may not come within 1,000 feet of this building, no victim contact. I do understand that he resides at that building, but frankly, Your Honor, I think that is to be an expected consequence when a court finds probable cause for the allegations that he is accused of today.
Okay.
Judge,
Yes.
first, his basically only contact with the criminal justice system is the offense that the state has mentioned, but my understanding is that DUI was broken down to a reckless, so he's on probation for reckless driving. Having said that, Judge, he is employed. He works at a local hospital as an orderly. He's been here in South Florida for almost 20 years. The only person that can help post his monetary bond is going to be his mother, and she doesn't work. Judge, I do understand that these are serious allegations, but I'm going to be asking the court, considering his very limited contact with the criminal justice system, I'm going to be asking for a $7,500 bond on Mr. Laverty's behalf.
And Your Honor, I do apologize. Upon a further review, He is on probation for reckless driving. I believe the significance really isn't what he's on probation for, but the mere fact that he is on probation.
How do I restrict him from going back to his only home if he
Well,
was to be released on GPS?
Well, Your Honor, that's why what I'm
Because if he was to be released, if I put him on the highest level of GPS monitoring, is he not permitted, he wouldn't be permitted to leave his own residence, would he not?
It depends. If the court orders a distance requirement, then frankly, he would have to find a residence that pretrial could verify, that's outside that distance. I don't believe the law limits the court.
No, I know it doesn't, but I don't see how, I think that I can impose enough restrictions that if he were to post this bond and be on a GPS, that there would be some sort of house arrest where he would not be permitted. Isn't, the monitoring, would it be a circumstance where if he were to leave the residence, other than to go to work, that we would know where he is?
Well, in
Yes.
fairness to pretrial, I know that's the case when we're dealing with neighbors of homes. I don't know, are we certain about that? We're talking about apartments here.
We're talking about a condo.
They live on different floors.
But he
So
does,
if he
what,
could just be confined to his floor, maybe.
no, everyone slow down, because we're all speaking over one another and the court reporters can't take down what we're saying. What I believe Mr. Linder's concern is not necessarily these victims but the propensity to potentially do this to another neighbor is what Mr. Linder's
And yes,
concern
Your
is.
Honor, based on these allegations, the information provided by the security personnel that a similar incident happened at a different apartment, I think every resident in that building needs the protection.
Okay. What assurances can GPS monitoring give me?
If it's the same building, it may not be able to tell if he's in someone else's residence because of the
And frankly, Your Honor, considering the proximity, all the GPS would do is tell us after the fact that he's there. There's no way if he wanted to go into the condo next door, there's no way law enforcement could reasonably be expected to respond, to be notified and respond by the time he could get there.
Mr. Romero, does he have any other family or friends that he could stay with if I reduce the bond and he's permitted and he's able to get out on the GPS monitor?
Let me inquire. Judge, he does have a good friend that lives in Tamarack. He believes he can go ahead and try and contact that individual and see if he would allow him to stay there during this case, or some other judge modifies it, but he did say it's a possibility.
I have to think about this one for a second. Can you all, I'm gonna recall this last on the docket. Give me a moment. Let's go
Yes,
ahead and
sir.
take care of Mr. Williams.
Mr. Williams, come on up, please.
Mr. Williams, I have two charges here that I've reviewed, a grand theft and obtaining property by fraud. The first count carries with it a $1,000 bond, the second count a $5,000 bond. Mr. Romero, is your client able to post these bonds, or do you want me to consider reducing them?
Judge, and speaking of Mr. Williams, he gave me the phone number of his girlfriend. I'm going to be reaching out to her. He believes, going through the services of bondsman, that she may be able to post his bond. So at this time, nothing to add by the defense.
State okay with the bonds as is?
Yes.
All right, I'll go ahead and maintain the bonds, finding probable cause. Good luck to you, sir. Stafford, Gregory Stafford. We have two petty theft
Stafford, come on up,
charges.
please.
Third subsequent offense on these petty thefts. What's going on here? Okay. These are on two different dates. I have two probable cause affidavits here.
Yes,
Are they
Judge.
gonna be two different case numbers?
I believe so, yes.
Okay.
If they're not, I imagine when this,
There's a dollar store one from March 20th and a dollar store one from April 25th.
yeah, Judge, frankly, I think one way or another, it may end up being two separate case numbers, but I can't guarantee.
Okay. All right, Mr. Romero, anything on behalf of your client?
Yes, Judge. Unfortunately, Mr. Stafford is financially indigent. He's homeless. However, he does have a mailing address where he could receive future court notices in order to make sure he goes to his court proceedings. He's 60 years old, been living here his whole entire life. Right now, he has a physical condition which he's going through, which prevents him from working. So, Judge, considering these are nonviolent offenses, Judge, I'm asking the court to consider releasing Mr. Stafford on pretrial release.
What's his background?
And it's mentioned in the first report, Your Honor, this is his third theft offense since he pled out one theft January 22nd of this year, another February 17th, another one July 5th of last year. Looks like, one moment. Going back to the mid-90s, he has a federal conviction for bank robbery. Was sentenced to 210 months in federal prison. He violated his federal probation in 2011. Those are really the highlights, Judge.
I'm just looking at what he's allegedly took, and it's
Understood.
unfortunately, Mr. Stafford keeps going back to the same dollar store. Is the address that's on the probable cause affidavit the mailing address that he has?
Is it a Hollywood address, Judge?
Yes, it's the Scott Street address in Hollywood. Sir, is that where you get your mail?
Yes.
I'm willing to give him an ROR as long as he, you have to understand, sir, you need to stay away from this dollar store.
Yes, ma'am.
If you're found at this dollar store again, I'm gonna, your bond will be revoked. You understand?
Yes, Your Honor.
Okay. All right, I'm gonna release him on his own recognizance. All right, next we have Jesse Jacksaint.
He's approaching, Judge. You're at me.
Thank you, sir. We have several charges pending, only two of them that I need to address. Actually, three of them. Three of them I need to address. One's giving a false, allegedly giving false identification to a law enforcement officer. Then there's possession of a weapon or ammunition by a convicted felon. I need to make a determination of your bond on that one. And then driving while license suspended, which carries a $750 bond. Your first one was a $100 bond. What's Mr. Jacksaint's background, and what is the state recommending regarding count 2?
Your Honor, considering the amount of ammunition that was found, again, I'd be requesting a $5,000 bond on count 2. Also, that he was giving a false name to law enforcement. His history: 2013, possession of cocaine with intent, tampering with evidence. 08, possession of cocaine with intent. 07, aggravated fleeing, eluding, resisting with violence. 03, resisting without violence, leaving the scene of an accident. Those are his most significant Broward priors. Nothing further.
Mr. Romero, anything?
Yes, Judge. He's not going to be able to afford quite what the state is asking for. He is working. He works at a company called United Water where he does cleanup, and he's been employed with them for 4 years now, making $13 an hour. He lives with his girlfriend, and his girlfriend relies on him for his financial support. Now, she does hair on the side. They live locally in Pompano Beach. I believe their monthly rent is approximately $1,050. He's been here his whole entire life. What I'm going to be asking for is on count 2 for the court to consider for a $1,000 bond on his behalf.
I believe that the state is being generous there. I'm gonna go ahead and enter a requirement of a $7,500 bond on this one, finding probable cause. Good luck to you, sir. Let's see, we have, Adlin Junior, is it Cydric? I may not be pronouncing that correctly.
Mr. Syriac?
Syriac?
Come on up, sir.
Mr. Syriac, you have a new charge of cannabis, which brings a $100 bond, and you do have a capias on a felony and a status hearing on Monday. Am I to set a, it says no bond, is that,
It's for, yeah, it's court order failure
it's
to
a
appear.
court order failure to appear?
Yes, I believe so.
Okay. All right, so sir, the judge's hearing that you missed wants you held on no bond until you see them, and you're gonna be seeing them on Monday morning at 8:30, so you can talk to that judge on that date as to why you happened to miss that hearing, and convince the judge to give you a bond on that one, so good luck to you, sir. Next, we have Dustin Wiggins. Where's Mr. Wiggins? These are ad charges.
Judge, I've been advised medical reset.
Okay, this is a reset from yesterday as well. Next, we have Brandon Woolery.
He's here at Main, Judge.
All right, Mr. Woolery, we have a pretty serious charge here of murder in the second degree.
Your Honor, I don't know if you reviewed this case in Odyssey beforehand.
No, I have not.
If I may approach then.
Yes.
Before you do, Mr. Linder, according to Odyssey, Mr. Woolery has retained Philip Massa as his attorney. Is that
Okay.
correct?
Mr.
Correct.
That's correct? All right, so.
Yes.
Okay, so Mr. Woolery, the public defender's office can't help you this morning because you already have an attorney. So do you want us to call your lawyer and have them come this afternoon and I can reset you to this afternoon, or do you want to go forward? At this point,
Yeah.
you want me to call your lawyer?
Yeah.
Okay, all right.
I did leave a message for Mr. Massa, but he has not yet called me back.
Well, maybe Mr. Massey's in court this morning and we'll get to him eventually. So, sir,
I'll
we're
keep trying
gonna,
him.
we're gonna call again. We're gonna leave a message and ask your attorney to come back after lunch and meet us here this afternoon. So I'll see you this afternoon, okay?
Okay.
All right,
Okay.
thank you, sir. So he's a reset to this afternoon. And you can give me the paperwork in the meantime, Mr. Linder. Thank you.
Yes, I will.
All right, next we have Luis Ruiz. Mr.
Luis
Ruiz.
Ruiz? He's approaching, Judge.
All right, Mr. Ruiz, there's not much I can do for you this morning. It appears that you have a violation of probation or community control. I don't see a hearing date scheduled, though.
It's Dade County.
It's a Dade County case. So you're being asked to be held no bond until the Dade County jail can come and get you, sir. So you'll be held until they can transport you, okay?
Oh, when are they gonna pick me up?
I have no idea, sir. That's up to the two jails. They'll make the arrangements, all right? All right, next we have, St. Josie Alvarez.
Come on up, Judge, sir.
Okay. This, we have two charges here, aggravated assault on a firefighter and a fleeing and eluding. These are ad charges, my understanding, yes, counts 4 and 5.
Change
Oh,
of
change of
charges.
charge, sorry, but this only says 4 and 5. Does he have other charges already?
Yes, they were either dropped or filed as presented.
Okay, so does he have bonds still, or what's the circumstances here?
Your Honor, what I'm going to be requesting I'll deal with charge number 4. That was an upfile from resisting without violence to aggravated assault. Now, when it was a resisting without violence, Judge Powell set it at 500. He had an additional count of aggravated assault on a law enforcement officer. She set that bond at $5,000. Considering she set a $5,000 bond on a separate aggravated assault, I'd ask that the court set a $5,000 bond on this aggravated assault. On the fleeing with disregard to safety to persons or property, it's essentially a lateral technical change of charge from fleeing and eluding. The $10,000 bond that's there on your findings, that was the bond that Judge Powell originally set as well, I believe. So I'd ask that be kept in place with all the other release conditions that Judge Powell set, which is pretrial release and the GPS monitor.
Anything from you, Mr. Romero?
Judge, I mean, if his bond on count 4 was previously, I'm assuming $1,000, and now the state is requesting a higher bond amount, he's not going to be able to afford that amount because he's been in custody all this time. So I just wanted the court to take that into consideration.
All right, I'm going to go ahead and adopt the state's recommendation. All the other bond conditions will remain in effect, and count 4 will be noted as a $5,000 bond. Thank you. And almost last but not least, we are going to go back to the other case, but we have Eric Charles Roberts. Where's Mr. Roberts? Conti, thank you. All right, Mr. Roberts, good afternoon, sir.
How you doing?
Good, thank you for asking. Unfortunately, I don't know that there's going to be really much of a change that I'm going to be doing regarding your case. It appears that they charged you on a file that you've already been in front of the judge on. There's a count 8 now of a grand theft, and they're asking that I add a $1,000 bond there.
Okay.
So I'm really not doing anything, and it was really administrative for us
No
to
problem. I'm
bring
waiting
you.
to see the judge.
Okay, sounds good.
Mr. Roberts has a no bond hold anyway.
All right, thank you, sir. Good luck to you.
Thank you.
Good luck,
All
Mr.
right.
Roberts.
All right, I believe that all we have left is the one gentleman at the main jail that I needed to take a consideration of. I am going to go off the record for just a moment and read this probable cause affidavit one more time with the understanding of what everyone's asking me to do now and putting that in perspective. So if you all would just give me a few moments, okay? All right, we're back on the record, everyone. Thank you for indulging me. Mr. Romero, you have Mr. Laverty there?
Yes.
All right, anything else, Mr. Romero, you want me to consider after having an opportunity to speak to Mr. Laverty a little more?
Judge, all he can say is, Judge, he promises to abide by whatever the court asks, he wants to still reside at his premises with his mother. It's close where he works. Judge, I did tell him that he'll have his day in court to address these allegations. But Judge, as you can see, he has very, very limited contact. The only thing in his past is something that was alcohol related. Judge, at the end of the day, that might be something that we're going to be focusing on. But at this time, Judge, I'm just asking the court to consider allowing Mr. Laverde to reside at his premises.
And Mr. Romero, if you need to go off the record for just a second to ask your client this, does his mother live there full-time, or what's the circumstances regarding who else lives in the home? If you could find that information out for me.
They were sleeping. He woke up and was in front of looking at him.
Judge, yes, his mother lives there full-time. I know their lease is up in 2 months, and basically, Mr. Laverde with his mom are going to be looking for other places to live at the end of their lease.
Okay. Given the circumstances, I'm not even sure that the condominium association is going to want him back. I don't know what their rules are regarding leases and invitees and whatnot, but I'm concerned. With the understanding of what Mr. Linder was explaining to me and what he believes would safeguard that community versus what I've read on this, I happen to agree with Mr. Linder. I don't believe that he should be permitted to go back to this building. If he can make other arrangements with his friends while his mother looks for someplace else to live on this lease, that's entirely up to them as a family. But the GPS monitoring, unfortunately, is not going to safeguard the other occupants in this building, given the circumstances of this case. Mr. Linder, what did you suggest as a monetary bond?
Well, I think I requested 25,000 because this was someone's home, which was occupied, and I reread it again, and I didn't even realize that it went into further detail about the prior incident where it's strikingly similar allegations. And I still think there needs to be a GPS in case he decides.
Well, I'm definitely doing
okay.
a GPS.
Okay,
That's without a
okay,
doubt.
okay.
That's without a doubt.
So, yeah,
The GPS, not in this residence. If he wants to look for someplace else where the circumstances can be better monitored in a home, that's fine. But I'm absolutely putting the level 1 GPS monitoring in with the no victim contact and the no return to this particular building.
And while I certainly don't condone it, I can, this isn't your typical burglary, someone breaking in to steal someone's property.
We don't know what the alleged breaking in and or the alleged purpose behind this all is. I don't know.
I'm just referring to both victims both residents advising people that when they woke up, they found Mr. Laverde in their room staring at them. So it's I can.
I don't know, and I'm not going to speculate either. I'm just here to try and determine what the safety of the community is, as well as ensuring that Mr. Laverde returns to face these charges. I'm going to go ahead and institute a $25,000 bond with a level 1 GPS monitoring, no victim contact, and no return to the building.
Judge, I'm going to ask the court to reconsider reducing that monetary bond to $7,500. I believe prior to the court going off the record, I know when the state suggested their bond amount, they actually did talk about the facts as far as that this was done on a previous occasion. I believe the court was going to entertain, if the court were to impose that no return to the premises, the court may consider a lower bond, something more accessible to Mr. Laverde. I did advise you that he works at a local hospital as an orderly where he's been employed there for 7 months, making only $11 an hour. His mom does not work. He has basically no prior criminal history except for that reckless driving, which was basically alcohol. And I believe in the future, this may explain some of what happened. So, Judge, I'm going to be asking this court to reconsider and setting a bond of $7,500.
I'm not inclined to do it. I'm sorry, Mr. Romero. All right, that concludes our docket for today. This morning, actually, we'll see everybody back this afternoon. I'll stay around for a few moments to go ahead and sign whatever needs to be signed, okay? Thank you, everyone.
We're requesting a phone order on his behalf, Judge. Sorry.
No problem. Phone order, we got it. Thank you, everyone. Have a nice lunch.
What time are we